First, we're going to talk about federal regulation under the Farm Bill that was adopted in 2008, the GIPSA requirements, Grain Inspection, Packers and Stockyards Administration. Then, we're going to talk about some insurance issues. We have a recent Iowa Appeals Court decision that I think will be of interest to some of you that deals with contract feeding. Then we'll get into the lien issues, and we'll talk about a little bit about the landlord's lien, more about the contract grower's lien, but what we're going to focus on is the ag supply dealer's lien, the feed dealer's lien, and even if you're not a feed dealer, I think there was this is an issue we've talked about in years past. The courts couldn't agree on who won, and the Iowa Supreme Court has settled that, and I want to talk a few minutes about what that may mean to you if you're a producer, what it means to you if you're a feed dealer, and what it means to you if you're a banker. Time permitting, we'll get into some just general contract issues, negotiations, modifications, some of the specific just plain old contract issues on over to finish the talk out. Again, if you have questions, why please feel free to ask as we go. Also, I'll be around some afterwards, and also, I understand if you're here for a specific topic, and after I cover that, if you want to get upstairs to see something else during poor Congress, our security enforcement here, John Odie, will leave you alone and not tackle you at the door. Okay. Watch for my cue on that, John. Okay. All right. All right. Slide 2. Packers and Stockyards Administration requirements. Starting on June 18th of 2008, Congress passed the Farm Bill. In that Farm Bill, in addition to the normal Farm Bill provisions that cover government payments, etc., were provisions on swine contracts and poultry contracts, but since I'm here on behalf of swine today, we're going to focus on that. Any contract, production contract, or a marketing contract entered into or altered, amended, modified after June 18th of 2008 has had to have certain disclosures in it. What is a production contract? My definition may be a little bit different than what's looked at by the federal requirements, but I think I'll be pretty close. And of course, we have to follow the federal requirements. But in general, a production contract is when I own the pigs, you own the building, I put my pigs in your building, you take care of them, you do everything, daily care, maintenance of the buildings and care of the pigs, etc., and then I pay you for doing that. That's a production contract. Sometimes people look at, also we have leases out there, and you will have a lot of people refer to, I rent somebody's barn, or I pay barn rent for my pigs, but when in the actual case they are putting their pigs in that person's building and that person is taking care of their pigs, that's not a lease under the law. That's a production contract. A lease is when I put my pigs in your building, and then I take care of them. I do all the work. You don't do anything other than provide your building to me, like renting your house to me. All you do is rent the house, and I take care of everything else. The same way with the buildings. A lease, a true lease, then, is not subject to the GIPSA requirements in the Farm Bill or in the rule we're going to talk about, where a production contract is. Okay? With that, the law required since June 18th of 2008 that, looking at slide 2, since then, any contract that was changed or entered into is to have a disclosure that the contract producer, the contract grower, I should be using that term instead of producer probably, but the contract grower had the right to cancel within 3 business days after entering into the contract, and the contract has to have that disclosure on the in the contract on the first page, and then a disclosure on additional capital investments. That the disclosure is on the first page, that any additional large capital investments may be required, and I state on this slide, if not required, can disclose that none will be required. Now, I have to admit, I disagree with some of the interpretations that are being followed by the enforcement people here, and I'm not afraid to say that, but you have to follow what they're going to say. If McAfee says that he disagrees, you still get penalized, unless you want to pay me to fight it. And then we'll see if we win, okay, or pay anybody else. I don't believe that that additional capital investment disclosure statement should be required on the first page of a contract if you aren't going to require additional capital investments in the contract. The Farm Bill says it is. It says you must have this statement there. I believe what Congress meant was if you're requiring additional capital investments in the contract, if it says they are required, then you have to disclose that. That makes more sense to me than if I'm not going to require it in the contract, why would I have to disclose it on the front page that I'm not going to require it, or that, even worse, that I have to say they may be required when the contract doesn't require it. Okay? I just talked in circles there, but that's the way the analysis works. But the position of the GIPSA, the Packers and Stockyards Administration, is you have to have a disclosure there, and the understanding, the law doesn't say this, but the understanding is you can either say they are required or they are not required. Okay? Here's what I ran into a few years ago in doing a contract like this for one of my clients. I put on the first page, additional large capital investments may be required. The other party to that contract called my client and said, "What the heck are you trying to slide by me here? Why are you saying that additional large capital investments may be required? There's nothing in the contract. What are you know," and I'm probably exaggerating here a little bit, but I got a call from a client who wasn't very happy about, why are we putting that in there because the contract doesn't require this and the other side thinks we're trying to slide something by them. That's when I started putting a heading there that said, required by federal law. We must have this statement or whatever, so it's clear. That wasn't our idea. Federal law requires this statement to be there. Again, that's my analysis of the additional capital investments, but if you don't put either one of these disclosures in your contract that is entered into or modified after June 18th of 2008, a production contract, then you will be penalized. If the enforcement people come around, and they are doing that, they are conducting audits of pig owners' contracts, and if these disclosures are not there, there will be a penalty. The question was how much? I can just tell you what I've seen, and these are public. You can find them on the website. I've seen them all the way, and I'll probably miss the range here. Some I'm going from memory, from $1,500 all the way. I think I've seen them up to $40,000 or $50,000. I think I think we have some folks here who might be able to answer that question better, but I'll not put them on the spot. It is on the website, and if I haven't stated, you can just go to, if you Google GIPSA or Grain Inspection Packers and Stockyards Administration contracts, you'll find their website. They do have these listed, and you will be able to see exactly, these, when an order is agreed to, what's called a stipulated penalty, then it shows the amount. That's what I recall. Generally, that's the range, and it depends on how many contracts are out there, and there are other requirements other than what I'm talking about here. So, it is important as you sit here today, and if you don't have these disclosures in contracts, if you're the pig owner, that is the contractor, and if you have contracts out there that don't have these disclosures in there, please don't raise your hand or anything. Let's be real quiet. Let's talk. And you talk to someone else or whatever, and we'll see. You can go ahead and amend your contracts now to insert these disclosures if you are audited by the enforcement people, by GIPSA, even though you have amended your contracts to insert these. If they weren't that way from the beginning of the contract, if it was after June 18th of 2008, there will still be a penalty. The penalty will be more if you don't have them in your contracts and don't put them in your contracts as a result of the audit. Then the penalties will be higher. But generally what happens once the producers are audited, if they didn't have them in there to begin with, if they didn't amend their contracts prior to the audit to put them in there, they will amend their contracts at that time, and then we're talking about the amount of the penalty I just gave you. Okay? Yes, sir. Question?
I'm a little bit confused. Is the penalty on the writer of the contract?
Good question. And I'm going to repeat the questions today because this is going on the website. And I repeat it for a couple of reasons, so that people they can't always hear it on the microphone, and number two, I can change the question so I can answer it. But no. Anyway, who is the penalty on? The penalty is on the owner of the pigs. the contractor, not on the contract grower. The penalty, and that's a good point.
And my follow is that word.
I love that question. The question was, is by putting that disclosure in, and maybe this isn't exactly how you ask it, but by putting that disclosure in, is that giving the writer of the contract an option to actually require that? That is exactly the reason I say it shouldn't be in there if they're not required in the contract. No, I don't. To answer your question, I don't believe by putting that disclosure in there that gives the writer of the contract that option. I think the contract itself has to have some provision in it that would give the contract writer that option. But that is my whole argument with all of this, that by having to put that disclosure on there, it is confusing. Because if it's not in the contract, why am I putting the disclosure on there that additional large capital investments may be required? And again, I'm going to restate that so they can hear it. What you're saying is by putting that in there, the writer of the contract is saying that at some point we may come back and renegotiate to require additional large capital investments. That is certainly always an option. You can always renegotiate a contract. I think, personally, the better way to look at it is I'm putting that disclosure in there because federal law tells me I have to put that disclosure in there, and if I don't put it in there, I'm going to get fined. That's my best answer because, again, I think it's absurd to put a disclosure in a contract when the requirement is not in the contract. But that's my personal opinion. So, again, I think the questions you're asking, though, illustrate what contract growers reading this, if you see a disclosure that says additional capital investments may be required, that causes concern to me as a contract grower because I'm thinking, okay, what did I miss back here? I look through the contract again, I don't find it. I realize I've probably covered that issue extensively here, but I think it's a very valid question, and I don't think that's what Congress intended. They did not intend to confuse anyone here. Yes, sir. That's correct. That's correct. Okay, here's what. At one time it said on the GIPSA website that you can put a disclosure in the contract that says additional large capital investments may not be required. I, as an attorney on behalf of the Iowa Pork Producers Association, had a telephone conversation with the director of the Packers and Stockyards Administration who told me that was an option to say they may not be required, which I agree with you. It makes it clear then. They either may be required or may not be required. I'm telling you right now that's no longer on the GIPSA website, that it says you can put in there they may not be required. And there are some who may tell you it has to say they may be required because that's what Congress said in the law, okay? You're right, it is confusing. I have in my slide you can put either in there, which I think helps, which makes it less confusing. If the contract doesn't require them, put in the disclosure they may not be required. I'm telling you, you won't find that anywhere in the law, and you may not find that anywhere in any advice you're given on the website or whatnot. You may get the understanding that it has to say may be required. To me, that is very confusing, and that's why I think this requirement is absurd. Beyond that, now, so let's say you put either in there. To me, I don't think you should have to put any disclosure in there if the contract doesn't require them. Why should you have to say something may not be required when it isn't required? That's what I think is confusing about the law. In my opinion, and this is just my opinion, what Congress intended was if additional capital investments are going to be required under the contract, then you have to put the disclosure in there that they may be required. I don't think Congress intended that you had to put a disclosure in there for something that isn't required. All right. But to help, and I apologize if this is confusing, to help with that, I think the best approach is to put in there, if you're not going to require them, put in they may not be required. Then you don't send the wrong message to the contract grower. Okay? All right. I'm glad you're asking these questions. I don't want to confuse the issue, and again, I think the fact that we're having this discussion, I think, illustrates the fact that the way this is being administered, I don't think is what Congress intended, and I don't think there was any intent to make it this confusing. I think the intent was to protect contract growers who are entering into a contract that requires additional capital investments. They wanted disclosure right up front on the first page so that was clear that it was being required. If they're not being required, why would we disclose anything? All right, but there's a requirement. All right. Next, that was for production contracts only. On marketing and production contracts, so packer contracts, production contracts, we have a choice of law and venue issue. All right. First bullet point there, if the legal forum is located in the, I said that wrong. If you have a clause in your contract that requires the legal forum to be located somewhere other than the federal judicial district where the principal part of the production takes place, then you have a violation of your contract. Okay? Your contract cannot require that contract grower, if they're going to go to court over something, if the contract says venue shall be in such and such county in a state that has nothing to do where the principal part of the performance takes place, which is where the pigs are being raised primarily, then that contract is in violation of the Packers and Stockyards Act. So, if you have a contract that says that you need to change it, and the safest thing to say is the legal forum or venue will be in the federal judicial district in which the principal part of the production takes place, then you've complied with the law. Now, people reading the contract may not know where that is, but in general, or I believe if the contract is silent on this issue of forum, you're okay, because it doesn't violate the law. So I have... clients have told me during an audit that GIPSA has said they would prefer there be a clause in the contract that states just this. The contract may specify which state law applies unless state law prohibits that, and I'm not aware of any state I've dealt with where state law prohibits that. So if you're entering into a contract with an owner of pigs in Illinois and that says Illinois law applies, as an attorney, I might suggest to you that you try and get that changed so that it's in Iowa, because that's where you're raising the pigs, but that doesn't violate the federal statute unless Illinois law prohibited that, and to my knowledge it does not. Okay? All right. Arbitration. We'll talk a little bit more about this when we get to the federal rule. This is all from the Farm Bill itself, but the Farm Bill, when it was enacted in 2008, said that any contract requiring arbitration, do we all have a pretty good understanding of what arbitration is? That's when, by contract, you and the other party decide, instead of taking a dispute to court, we're going to have an arbitrator decide it. Okay? Not a judge, but an arbitrator who many times is an attorney, can be a retired judge, whatever, but you decide we're not going to court, we're going to arbitration. And if there is such a clause in the contract, that contract has to have a provision that allows the contract grower to opt out. They can say yay or nay to that arbitration clause. And that contract must conspicuously disclose the producer's right to decline. And again, we'll talk about there's some specific language that will be required in contracts after February 7. Okay, that's part of the final rule. All right. Okay, with that, we are on the final rule now. What I just talked about applies to contracts after June 18th of 2008. As many of you know, following the Farm Bill being adopted, then rules had to be adopted on certain areas of law, and they were very controversial. Last year at this time, we talked about all the comments that went in, the opposition to those rules, etc. Without going through all that, those rules were entered or adopted in final form first part of December. They go into effect on February 7, 2012. And right there are the three areas that are left in the final rule. A lot of what you heard about, a lot of the controversy was taken out of that was in the proposed rules, didn't end up in the final rule. What we're left with is three requirements: additional capital investments criteria for production contracts, and we'll talk about this, reasonable period of time to remedy a breach of contract in production contracts, and arbitration, which I've just talked about, and we'll add a little bit there. I'm going to move through this fairly quickly because I do want to get to the lien issues and some of these Supreme Court decisions, which I think from an everyday standpoint impact you as much or more as this. But again, I want to cover what you want to talk about today, and I'll be glad to go over. We're here till 3 o'clock, but I'll be glad to go past that to cover the issues you want to talk about. With that, this slide 6, is just my point that the way the rules are written, they are not the be-all and end-all of what the regulations can require, because they say that they are their criteria GIPSA may consider to determine a violation, and they say in every area, they say the following factors, including but not limited to. So the point is, GIPSA could consider other factors to determine if there's a violation. Do I think that will happen in most cases? No. I think they'll probably follow these criteria only in those cases where, and I don't know this for sure, we haven't had any enforcement. These rules don't go into effect until February 7. We'll find out for sure after that. But I think in most cases they will follow these criteria, and only in cases where they see some egregious circumstances, I believe they will look beyond that. But again, that's just my analysis at this point. What is an additional capital investment? I've talked about that. You know, we talked about the disclosure. Are they required? Are they not? What is additional capital investment? The rules define it as $12,500 or more per structure paid by the grower over the life of the contract beyond the initial investment. I'll leave the rest of that for your reading, except that look at that second bullet point. This does not include maintenance or repair. I think the shorter answer is it doesn't take very much to get to $12,500 per structure over the life of a contract. Okay, so I think, in my opinion, that threshold was set too low. And I think just about anything you're going to require that contract grower to do in the contract over the life of the contract, it doesn't take long to get to $12,500, which means the disclosures should, in all likelihood, be there. That's what this relates to. However, if at the time you require an additional capital investment, if the grower is reimbursed for that fully, which frankly, that's what I find in swine contracts. I think a lot of these rules were pointed at other types of contracts in other parts of the country, poultry, broiler contracts. I don't think we've seen a lot of the problems that these rules were shooting at. I think they were a solution looking for a problem, in my opinion, with swine contracts. But be that as it may, they are there. There's the definition of additional capital investment. The threshold, I think, is very low. I don't know what your thoughts are. Any questions on the definition? Here's the criteria GIPSA may consider to determine whether a requirement that a grower must make an additional capital investment over the life of the contract is a violation, and again, including but not limited to. Was the grower given discretion to decide against an additional capital investment? Was the additional capital investment requirement a result of coercion, retaliation, etc.? Does the other party to the contract intend to reduce or substantially reduce or end production within 12 months absent a catastrophic event? Were some growers required to make additional capital investments while others in similar situations were not? What about the age and recent upgrades to growers' operations? And can the cost of the investments be reasonably expected to be recouped? Okay. Was the grower given a reasonable time period to implement the required investment? And were equipment changes required for equipment previously approved and accepted if the equipment was functioning as intended unless the grower is paid adequate compensation incentives? Again, all this comes back to what I see most often in swine contracts is, say a producer, a contract grower has feeder pig to finish buildings, and the owner of the pigs now wants wean to finish. In all the cases I've seen, the grower is compensated for the cost of putting in the additional equipment to go to wean to finish. So under those scenarios, if the grower is compensated or outright paid to put them in, or if the grower receives an additional payment that allows them to recoup the investment, you're fine. I think the key, if I were looking at my contracts after this rule goes into effect, I don't know that any change needs to be made to most contracts. I think what needs to be done, if a grower at some point is required to make an additional capital investment, that is not maintenance or repair. Replacing gates or whatever is, in my opinion, maintenance or repair would not qualify. But if they're required to do something that qualifies as an additional capital investment, I would do a contract addendum here have the grower sign it, you sign it, go through it with them, and I would lay out all of these criteria I just read and put it in a contract and say, they were given adequate time and meet all these criteria, have both parties sign it at that time, and then I think you have covered the requirements of the law. Okay? Let's move on to the next part of the law, and that is reasonable period of time to remedy a breach of contract. What are we talking about here? You have a contract in place, the grower does something that is a default. What do you do as the owner of the pigs? Most often, you want to work with that grower, get that corrected. 9 times out of 10, that takes care of it. But if not, the rules, then, let me back up. Most contracts I've ever reviewed and or written have then, if there's a default, you provide a written notice to the grower saying you didn't do something you were supposed to. Here's the written notice, and you have so many days to correct it. 30 days is common, 60 days, 10 days sometimes. Whatever that time period is, the rules will now look at to whether that time period is reasonable. The first bullet point there in slide 12 is what I think we want to focus on. Was the grower provided, one of the things we'll focus on, was the grower provided written notice of the breach upon initial discovery of the breach? Circle that one, because I think, and we made comments, we being the association and others, that I think this could have unintended consequences to the detriment of the grower. What do the owners of pigs often want to, as I said, work with the grower, work through it. Well, you don't provide that written notice of breach right away. You try and work with them, and then if over several months, if it is not correct, if they don't come around, then you provide a written notice of breach. This says one of the factors GIPSA will look at to determine if there's a violation of the law, if there's a breach that could lead to termination, were they provided written notice upon initial discovery of the breach. Now, I've written an article on this for the Iowa Pork Producers Association that should be coming out in the magazine shortly, because this last magazine was devoted to Pork Congress. But in that article I say, does this mean that you as an owner of pigs now can't work with the grower as much? You have to provide that written notice of breach upon initial discovery versus not providing it for a few months and trying to work with them? Could this be to the detriment of growers? I'd like to encourage you to still work with growers to correct breaches instead of sending out a legal notice of upon initial discovery of the breach. But the rule says what it says, and it is a factor that GIPSA may consider to determine if you're in violation. Okay, slide 13. Did the notice of breach? So at the time of the breach, and you send out the notice, this notice, as the owner of the pigs, I keep saying you, if you're the contract grower, this is the notice you will get. It has to have these 4 things in it. That's what the rules say. In my experience, most notices of breach would have this in it anyway. The other thing the rules say, did the other party, and this is again when GIPSA is looking at if there's a violation of the law, did the other party take into account the grower's ongoing responsibilities related to raising and handling swine when setting the date to remedy a breach? I don't know exactly how to answer that one. Was the grower given reasonable time after the notice of breach to rebut the alleged breach? Circle that one. If you are looking at what to do to your contracts after February 7, 2012, I think one of the few, I think a lot of this stuff comes up at the time of a breach, but I think this is one thing you probably need to look at your contract, and if you have a 30-day period to cure a breach, I think you probably should think about adding in there that 30-day period includes the right to rebut the breach. What do we mean by rebut? Argue, provide their side of the story that no, there wasn't a breach, or here's why I breached, or whatever. I've never seen a contract, and I've reviewed quite a few in my day, I've never seen a contract that during this 30-day cure period said anything about rebutting it. But now the federal rules include that as a factor, and I've advised my clients anyway that you ought to include in that same 30-day period, 10-day period, 40-day, whatever it is, that it includes the right to rebut the alleged breach. Okay? All right, that's it for the reasonable period of time to remedy a breach of contract. Okay, and in this article that I've got some more discussion there. I'm trying to think. Just generally, I don't think it's things that you really need to focus on changing contract language, but more what you need to take into account if you're the grower receiving the notice of the breach, or if you're the owner of the pigs providing the notice of the breach, what needs to be done at that time to avoid a problem, a violation with the GIPSA folks. Okay, slide 15. Arbitration. We've talked about it has to include the right to decline. The rules now say it must have the following clause, which is on slide 16, on the signature page in bold, conspicuous print. If neither option is signed for the right to decline arbitration, there it is, slide 16, and that language is word for word out of the rules. I would suggest you use that language word for word out of the rules. If neither blank is checked there, then the rules state, as you can see in this language, that the contract grower is deemed to have declined arbitration. Okay? So, what do you need to do to your contracts? If you have contracts out there with an arbitration clause in them, since June 18th of 2008, you have had to have some type of clause in there. If you do anything to those contracts, amending them, altering them, or entering into new ones after February 7, 2012, you need to have this clause in there, not just the clause you've been using, this exact clause. And slide 17, circle this if you're using arbitration. In bold, conspicuous print, you need to describe the following so that the grower, or if it's a marketing contract, a packer contract, and you're the producer, you need to make sure this language is there. Not that you're going to be fined, the packer would be, but so that the grower or producer can make an informed decision on whether to elect arbitration. So these three things need to be explained in there. Who pays the arbitration costs, the arbitration process, and any limitations on legal rights and remedies. Okay? That needs to be there. Now, I don't have language for you there because there's nothing in the rule. I'm going to have to leave that up to you if you're the one writing the contract. I think, again, there has to be something on these 3 points. Okay? I need to go back. There was one point I neglected to make, and then I think we're done unless you have questions on this part. Go back to slide 12. All right? I neglected to mention, and it's not in the slides, so please make a note. This reasonable period of time to remedy a breach of contract by rule does not apply. And I'll try and correct this for the version that goes up online because it should be in there. It does not apply if there's an exception for animal welfare and food safety. So, if you're the owner of the pigs and the grower is not doing something that affects the animal welfare, the welfare of those pigs, you're not limited by this reasonable period of time to remedy a breach of contract. You can take immediate action to protect the welfare of those pigs or to protect food safety. Now, I would caution you, if you're the owner of the pigs, I would caution you about be careful. Don't, truly make sure, we all want to make sure those pigs are properly taken care of, but I think there will be a lot of scrutiny given to whether if you take immediate action to terminate or do something that could lead to termination, that it was truly an animal welfare issue. Okay? Question is what will HSUS do about that? That's one question I don't have an answer to, John, because I don't know what they're going to do.
It would seem to me that they could go hog wild with that.
John just said it seems to him they could go hog wild with that, and I don't think you intended any pun there, right? But no, I don't know how to. Yes, I think this will be one. Animal welfare issues are a serious concern to our industry, and if you as the owner of the pigs or believe that a contract grower is not properly taking care of the pigs so that there is an animal welfare issue at stake, the rules are clear. You can take immediate action and should and must take immediate action. So I think this is a good provision in the rules. What is not there, and this is in the article, I didn't get it in the slides, what is not there is an environmental issue. That's not an exception. So you probably need to write that into maybe a shorter period of time to remedy any environmental issue, or if you're going to take immediate action, you need to be able to justify that that was reasonable. Okay? I'm sure we'll be talking about this stuff again next year. I realize as we run through this in an hour's period of time, some of it may not add up. I would also encourage you, as you think about this, go through it, feel free to give me a call if you have any questions. I want to make sure the information we're putting out here is correct, and it helps me to talk through it with you probably as much as it helps you to maybe talk with me. All right. More on arbitration. I'm not going to go through these factors that GIPSA will look at if they believe there's a violation. I will leave that to you because, quite honestly, some of these on slide 18, for instance, last bullet point, a reasoned written opinion based on applicable law and legal principles and precedent. We could spend the next 20 minutes talking about what that is. A reasoned written opinion is a term of art for arbitration. I really don't want to take our time today. If you have any questions about that, I'll be glad to answer them. Otherwise, consult your legal counsel. Okay. Done with the federal rules. Any questions about those? Yes, sir. Yes, and what you're saying is, and just so I can repeat it, is that you're saying the way we've talked about it today is the parties would be required to work it out as to what that investment is, etc. That's if you can spell it out in the contract that says you have to do this. Right. If it's not spelled out in the contract, then the parties have to work it out. Okay. Okay, the question is, what if it's a third party coming in and requiring the additional capital investment to be made, like a government requirement? Change it, change in governmental regulation that says you have to have something different, like a different manure storage or whatever. Maybe you have to file manure management plans when you didn't have to before or whatever. Again, I believe as a matter of contract law, if it's not spelled out in the contract and if it's a requirement that applies to the owner of the pigs, then they would have to negotiate to have the contract grower do that. On the other hand, if it's some of our environmental requirements apply to the owner of the buildings, which would be the contract grower. And again, I'll use the standard lawyer admonition. If it's not spelled out in the contract, if government requires that contract grower to do something for environmental compliance, and if it's not spelled out in the contract, that would be the requirement of the contract grower to pay for that. If that, again, it all comes back to what the contract says. But these are good questions, and this is helping me think through a lot of this. I've written a lot of contracts in my day, and I've helped write a fair number of regulations, assisting through my association clients, and you can never think of everything. But I think you do your best when you're writing a contract, and then you try and work with both parties as you go through the contract. Okay. Any other questions about the GIPSA or Federal Farm Bill requirements? Okay. Well, we're 45 minutes into it, but I think we had a good discussion of that. If I have totally confused anyone here and you don't feel comfortable raising your hand and you have time afterwards, please stick around. I'll be glad to try and either unconfuse you or confuse you more, but I will do my best to try and sort through this stuff, okay? All right. We're switching gears now. Slide 19. Livestock feeding contracts and insurance. Those of you who have heard me talk on this issue in years past have heard me stand up here and say, or whatever talk I've been giving, if you're a contract grower, and that is feeding somebody else's pigs in your building, your standard farm liability policies, just your run-of-the-mill farm liability policies, 9 times out of 10 won't cover you if something happens to those pigs that can be attributed to your negligence, okay? Somehow somebody determines you were negligent, pigs died, you didn't own them, but they were in your buildings under your care. The standard type of farm liability policy won't cover that. One of the worst calls I get, I've said this before, is from a contract grower saying, I had a problem, I shut a breaker off to work on the building. I forgot to turn it back on. Pigs suffocated. I called my insurance agent. Insurance agent says I don't have coverage, so now I have to pay for the pigs. I have stood up here for several years and said, you can buy coverage. You can buy a rider to cover that. what we call care, custody, and control coverage, what we call custom feeding coverage. There are companies that offer that. There are some upstairs. You can find others. You can get covered as a contract grower. Sounds great, doesn't it? Go to the next slide, slide 20. This is a case that came out in favor of the contract grower, but what happened was, and I'm using names here because it's a case, a public record, the contract grower purchased a policy, just as I and others had advised contract growers to do. He purchased a policy rider to cover custom feeding. The insurance company, well, next bullet point points out the hogs that were fed under contract died from suffocation. The contract grower filed an insurance claim, and the insurance company denied coverage. Without getting into the details in the case, you can look it up online. The insurance company argued that there was no coverage, even though there was a specific rider for custom feeding. They denied coverage because of other exclusions in the policy. Okay? I'll leave it at that for now. The court, the trial court, ruled in favor of the contract grower for what we call the reasonable expectations doctrine. There's a doctrine in the law that says if you purchase coverage and reasonably expect to be covered, and are not, that the courts will rule in your favor. You got to be careful with that. It's not used all that often, but it is a doctrine in the law. It goes up to the appeals court then. The insurance company appealed. The appeals court found there was coverage. Go to slide 21. So the appeals court ruled in favor of the contract grower and said there was coverage even though they denied your claim. And I think I've quoted the appeals court word for word here. In essence, what the appeals court said was, if the insurance company they sold you the rider, so you were covered for custom feeding your hogs, and if you weren't going to be covered, they had to say that explicitly and clearly that even though you have this rider, you're not covered for this, this, and this. They didn't do that. The court said, therefore, it was ambiguous, and they interpreted it against the company and provided coverage. Okay? That case has now been petitioned for further review to the Iowa Supreme Court. We don't, as of yesterday anyway, or day before, it hadn't been ruled on. But good decision for contract growers here. Bottom line is, if you're purchasing this coverage, if you have this coverage as a contract grower, take another look at it. Because I hope this decision stands, but even then, take another look at that and make sure that even though you have the custom feeding endorsement, that there aren't any other exclusions in the policy that could blindside you or come in the back door and nail you and not allow you to have coverage, or at the very least have to fight about it. Because you don't buy insurance coverage to have to fight about it. You buy it if something terrible happens, you want to be covered and move on. Okay? Any questions about that? Very important decision for the contract feeding industry. And now there was a case in Minnesota that went the other way. So, yes, sir.
You ever have the instance where the owner of the pigs actually carries that coverage?
The question was, have I seen where the owner of the pigs carries that coverage? Yes, I have seen that. Yeah, the question is, wouldn't that be a more efficient solution? And yes, that helps. But you know what happens? So the owner of the pigs has coverage to cover suffocation because they own the pigs. They then, and let's say this exact same scenario, they turn it into their insurance company. Their insurance company, and I'm not saying this is, well, I have seen this happen. That insurance company will pay to the owner of the pigs. They'll turn around and file a claim against the contract grower under what we call subrogation rights and claim then that, well, we had to pay it to our insured, but you were negligent, so therefore you're liable and we're turning to you for the reimbursement. So, very good question. Even if the owner of the pigs has coverage, it's still important for the contract grower to have coverage. Okay. Any other questions? Slide 22, landlord's lien. A lot of this applies to farmland. There is a lien. Landlords we're moving into liens now, obviously. And again, I want to get to the ag supply dealers' liens, but landlords' liens, when it comes to livestock buildings, we still see that, if you, like I talked about, a lease of buildings, The owner of the buildings, to protect their right to payment, should file a lien. It has to be done within 20 days after the tenant takes possession. And what that means is then the landlord's right to payment has priority to the secured lender of the tenant. You have a lien on the property in that building, which would be the hogs in this case. If it's farmland, landlords of farmland, if they file their landlord's lien, then they have a priority lien in their crop, the corn or beans or whatever it is. Again, we could spend a lot of time talking about that. Unless there's any questions, I will move on. All right, the contract grower's lien, slide 24. This is, well, again, a topic we've covered a lot in the past. Sometimes liens are a controversial topic. I've given this speech to bankers, and I've said this before. What liens really do is you have your collateral, in this case hogs. The bank that has loaned, or the lender, I shouldn't just say bank, that has loaned money on those hogs wants to be in first place. Okay? There are other people who are providing services related to those hogs, whether it's a contract grower or a feed supplier, and Iowa law provides that they can do something to get in first place if there's not enough money for everybody to get paid. If there's a financial problem, they can file a lien and get ahead of the bank who already has a lien on those hogs. Anytime you have anybody filing a lien to get in front of somebody else, you have winners and losers. For every bank that loses when a contract grower lien steps in front of them, there's a contract grower's bank that says, good job, because you just helped us make sure we get paid. But that same bank can be in a position where they're the bank loaning on the hogs in another case, and they get knocked out of first place. So again, liens are controversial, but it means when there's not enough money to go around, who gets to be in first place. You always have the claim against the person who owes you the money, but when liens come into play, that usually means the person who owes you the money doesn't have enough for everybody. All right. Production contract liens. If you're a contract grower, I urge you to take a look at this, to file these liens within 45 days after each group that when the hogs are delivered, you file a UCC1. Many times the question is, doesn't that mean I don't trust the person who owns the pigs? I'm saying, hey, I've got to file a lien. How many times have you borrowed money from a bank and the bank has said, well, we trust you, we're not going to file a UCC1? No, they loan money, they're in the business of doing that, they may really trust you, but they still file their paperwork. If you're a contract grower, I don't think it means you don't trust the owner of the pigs, it means you're just doing good business. Now, I'll talk about a lien for the owner of the pigs here in a minute. All right, I'm going to skip ahead to the ag supply dealer's lien. Again, I'm coming up on 5 minutes till 3. I'm going to go over my time. I understand if you want to get going and to other parts of Port Congress here, but I'll be glad to stay afterwards and make sure or go over the time limit. Looks like we'll probably get done about a quarter after, somewhere in there. But just want to tell you, if you have to get going, I understand. Ag supply dealers liens. This is the lien for feed dealers. It's been in the law since the 80s. When we talked about this last year, I said, here's some courts that have ruled this way, and here's some courts that have ruled this way. Some courts had ruled that the feed dealer wins. Some had ruled that the bank wins. Here's what was going on. For feed, I'm talking about, it applies to feed, seed, chemicals, and fertilizer, but the controversy was for feed. And the controversy was, the law had a provision in it about sending a certified letter. If I'm the feed dealer and I want to take a lien in those hogs to make sure I get paid, the law said something about sending a certified letter to the bank, and then the bank could respond with, yeah, there's enough net worth, no, there isn't, or they could ignore it. That was, in my opinion and others, a rather confusing provision of the law, and what was most confusing is it wasn't clear whether a feed dealer had to do that. The law had this clause in one part of the law, but then when it came to the feed lien, that clause that referred to that certified letter requirement wasn't there. So we had courts ruling both ways. Some said the feed dealer had to do it, and if you didn't, you lost your lien. Others said they didn't. That's what I'm talking about on slide 27, the certified letter to secured parties. Now, I've said it is not required on... Yeah. All right. The Bar Association union says I'm done, right? Well, I've gotten subtle reminders to be quiet before, but okay. There we go. Slide 29. The Iowa Supreme Court has settled this. They have said, and I won't go through the details here, and we have an article that will be out for the Pork Producers Association to discuss this decision, but the Supreme Court settled it, and I kind of laid their analysis out there, but they said the certified letter is not required. So, if you're a feed dealer, or working with a feed dealer or whatever, if you're a banker or a producer, but the feed dealers are the ones that have to do this, if you want a lien in those hogs, now look at the bottom, and I have it in a previous slide, but the bottom line on slide 29 is, your lien is not, you don't get it for the acquisition price of the hogs, okay? The bank gets to keep that. You get a lien for any of the value of the hogs above that, and hopefully there's enough value to cover your feed. Some markets we've seen that's been an issue. But you get a lien at least for that portion of the value by, what do you have to do? You have to file a UCC1 with the Iowa Secretary of State, and it covers feed purchases in the previous 31 days. So if you're providing feed as a feed dealer and want this priority lien to assure payment, you have to, in essence, what I tell my clients is file it every 30 days. You may have some feed purchases gap in there, but just do it every 30 days. While those pigs are being fed on that site, you're covered and your lien is in effect then, because it only covers the previous 31 days. Okay? Let me see here. I want to go back here and just take a few minutes here. I've had some conversations with with attorneys for bankers and for producers out there, and for bankers. I think now it's clear that feed dealers can get this lien by doing what I just said. How will this affect credit? Will this affect how bankers want to loan money on hogs? It may. And here's what I'm hearing. I don't know if this will come to pass because this decision just came out December 30th, but some are looking at putting in the loan covenants to the owner of the pigs, to the producer, putting in loan covenants requiring to get subordination agreements from the feed dealer so that before they'll loan you money as the owner of the pigs, you have to go to the feed dealer and get them to sign some sort of subordination agreement that they will give up their lien for feed, that they won't file a lien, and others I've heard bank attorneys that say, well, maybe what we'll do now, just to protect ourselves here, we will just say that we'll just pay the feed bill directly. Instead of paying if we think it's an account that may be in trouble, the bank will pay the feed dealer directly. I guess that sounds okay. But what I'm saying is if you're the producer, the livestock producer, the owner of the pigs, and the next time you refinance, if you want to pay careful attention to any loan covenants that might be here as a result of this decision, because they could affect you. We know how loan covenants work. If there are problems down the road, what can happen is you can get a letter saying you're in violation of your loan covenants, and maybe it's because maybe it's something out of your control. Maybe the feed dealer goes ahead and files the lien or doesn't send monthly feed bills. Just all I'm saying is pay careful attention if there's anything in your loan documents as the livestock owner that relate to these lien filings, okay? All right, there is also a veterinarian's lien. I'll leave that alone for now, let you read that. Here's what I was talking about before, slide 31. I've talked about contract grower liens, but if you own the pigs, this is not really a lien, but what you can do is, here's what happened in South Dakota a few years back. Cattle on lease from a company in Minnesota to a producer in South Dakota. The producer in South Dakota turned out to be less than a reputable individual. The producer in South Dakota leased these cows, didn't own them, leased them, turned around and pledged those cows as collateral to his bank. In essence, telling the bank that he owned them. He didn't. As you might suspect, the deal went south. The bank, his bank, in the fight over the collateral won. They got the cows because the owner of the cows from Minnesota had not filed what we call a UCC1 protective filing that we talked about there in slide 31. So, don't see this a lot with hogs, but to be safe, if you own hogs and if you have a contract grower that you're maybe not real comfortable with, let me put it that way, or even if you are, it might be good business to go ahead and file these protective filings. What you're doing is putting the public on notice through the Secretary of State filings is that I own those pigs that are in his buildings. While some people might think that if they're in his or her buildings, he or she owns them, I own them, and I'm telling you that in this filing, and that way you protect yourself if there's ever a fight over who has the collateral. Okay. Termination, like slide 32. You know, as I said, liens are somewhat of a controversial topic with some people because it puts somebody in front of somebody else as to payment. I think termination is important, both from a legal perspective. What the law says is if you have a lien and you're paid, you must terminate it within 20 days after getting written notification from the other party to terminate it. So the opposite of that is if you're paid and everything's fine, but the other party doesn't notify you to terminate, you're under no legal obligation to do it. But I think it's a matter of good policy that if you're filing the lien, if you're the contract grower, if you're the feed dealer, whatever, if you're paid, everything went fine, you didn't need the lien, terminate it. Keeps good business relationship with those that you're doing business with. Okay? All right. I'm going to skip over slide 33 and 34. I guess we're just a little bit after 3 o'clock, but these are on selling products, and I think I'll leave those to your reading. That when you sell products, well, I'll say I'll leave it to your reading, then I go ahead and talk about it. But it comes to a surprise many times to people that if you sell something, are not paid, if it's a farm product and you're not paid, that you think, okay, that's still mine, I'll just go get it. Law doesn't work that way, because if whoever you sold it to, their bank, if they have a security interest or a lien in that, if you sold them pigs and the buyer has a bank that is providing financing, even though they haven't paid for them, if that's a blanket lien, they now have rights in those collateral that are above yours. Doesn't seem fair, but that's the way it works. If you're selling farm products such as pigs under contract, I'm not talking to a packer here because we have packers and stockyards protection here, but if you're privately selling pigs, etc., wean pigs, feeder pigs, whatever, you should have a clause in your contract that gives you a security interest in those pigs until you're paid. That will help, but you have to require a subordination clause, etc. Of course, the safest thing is to get your money right away. You don't need a lawyer to tell you that. Number two, the next safest thing probably is getting a letter of credit. I've seen a lot of contracts where if you're a sow unit selling pigs, you get an irrevocable letter of credit to cover from the buyer's bank to cover the situation where you don't get paid. Banks don't hand those out all the time, but it's at least worth trying to negotiate something like that. The key is to understand where you stand if you're not paid. Okay, said I wasn't going to talk about it, and I did. All right, any questions there? Now, the remainder of the slides are where I've talked about these in years past, and I don't think nearly as important as the lien issues we've talked about, the GIPSA rules. And, of course, we are, I'll give a plug here, we're doing a series of, we being the Iowa Pork Producers Association, we're doing some spring seminars, regional seminars coming up the first week of March. And I'll be covering a lot of these issues, and hopefully I'll be more information on how the liens are working, as a result of the Supreme Court decision. More information on the GIPSA rules. I'll be covering that, and I'll try and go into more detail here. But the slides from here on out, what are they? Slides 35 through the end. Really, are we talking about contract negotiation, issues like that? I guess if... just some of the questions I get. Let's go to slide 36. Wait a minute. Let me back up. Slide 35. The bottom two bullet points there, or the bottom three, and this may sound pretty dumb, but I say if it is in the contract, you must do it. If it isn't in the contract, it isn't part of the agreement. And that, you think, gosh, that's pretty simple. But I think all of you who work with contracts know that sometimes people sign these contracts, they don't read them very well, and they go by what the other person they're negotiating the contract with tells them. Don't do that. The contract is what controls your agreement. If you have been told by the other person you're negotiating the contract with that, oh, even though that's in the contract, we don't enforce that. You don't need to worry about it. Okay, that's great. But just say, why don't we just take it out of the contract then? Let's just cross through it and both initial it, or let's write a new contract. That's the best way to really find out if you are really going to have to do that. Because if they say, no, we have to leave that in there, but we aren't going to make you do that, I think that shows a red flag. All right? The second part of it, if it isn't in the contract, if they say, oh, we'll do this for you, but it's not in the contract, but we'll do that, well, they may. That's great. But why not just put it in the contract? It just makes life a lot simpler, and for people who are getting to my age and older, it means you don't have to have as good a memory. Because in the next slide, slide 36, I talk about oral agreements, but let's back up. Almost all contracts have a clause. I'm back to slide 35, that last bullet point. Almost all contracts, written contracts, have a clause, what we lawyers call an integration clause, meaning that if it isn't in the contract, this contract supersedes all prior negotiations and oral agreements, and this is the deal. So, and it'll say any amendments must be in writing and signed by both parties, etc. So any verbal agreements on a written contract, if push comes to shove, and you may not be dealing with the person who you negotiated the contract with when that push comes to shove, most likely they're going to say, well, I don't care what they told you. It's not in the contract, and therefore, no, it's not part of the contract. So if you have a written contract, get it in the contract. Then I go to the next slide, slide 36. I was given this talk, and somebody said, well, wait a minute. I was talking about the GIPSA requirements, and they said, I don't have a contract. I just have an oral agreement with the neighbor. Or they didn't term it that. They just said, we just do it, and we've agreed to things. Well, I'll leave the GIPSA part of that alone, but under the law, contract law, oral agreements are binding. I told him, I said, you've got a contract, you just don't have a written contract. And I, of course, put in parentheses there to my a typical lawyer CYA in most cases. But in most cases, oral agreements are binding. Why don't we use them? Difficult to prove. Who said what? If things go wrong, hey, you told me this. Well, I don't think I said that. I said it this way. That's why we put them in writing. And number two, what I just said, hard to remember what the agreement was. I think many times the disagreements are not, there was a misunderstanding, or the parties just plain don't remember. And then here's where I have, again, the point about the integration clause, and that almost any changes that have to be in a written agreement must be in writing.